Good morning. See, again and again I used to state that so far fundamental rights are concerned, every right is with reasonable restriction. There should be some limit for exercising the fundamental rights. Like that, when equality, discrimination, and equal opportunities are concerned, there should be reasonable classification for denial or concession. So these things are most important. One more important judgment was pronounced by Supreme Court. So for unlawful activities, Prevention of Unlawful Activities Act 1967 is concerned. That related to 191AC. Here AR 2023 Supreme Court 1685 Arup Buyan versus State of Assam another. A reference, full bench reference was forwarded to decide whether American judgments cited are applicable in India so for unlawful association memberships are concerned. The Supreme Court has categorically held that membership of banned organization does not incriminate a person unless he resorts to violence or incites people to violence. This is finding of American decision. By following this American decision, several accused were discharged or affairs were quashed. So that resulted referring to full court judgment. This is what the division bench of this court in the Ranif case, while relying upon numerous American decisions concerning freedom of speech and the position on membership of banned organizations, rejected doctrine of guilt by association. So mere membership itself is not offense. That was previous a decision of our Supreme Court by referring American citation. But here, this full bench judgment, Justice M.R. Shah, C.T. Ravikumar and Sanjay Karol delivered this judgment delivered on 24/3/2023. They say that is different, this is different. Once the activities of the said association is declared as unlawful association, so being membership itself is since liable to be punished under section 10 class A1 of the said act. The judgment of American courts are not binding because the American Constitution is totally different from that of our Constitution. That's what our Supreme Court says. Because our Constitution did not simply followed in Indian Constitution. Indian Constitution was drafted by Dr. Ambedkar by following multi-number of judgments. Here they say the foreign judgments, particularly US Supreme Judgment, were about interpretation of laws of United States without adverting to differences and position of law in India. The act which was prevailing in United States of America is something different, that any person indulging in unlawful activity. Here in India, the membership, the association itself is being declared as unlawful association, and if any membership, that itself is an offence. Therefore, they have finally given finding stating that the reference is held that the Supreme Court, that the American judgments are not applicable to its multi-number of judgment pages. Finally, the Supreme Court held they simply held as issues in functioning implemented such rights were faced right from the start. So the lawmaking authority, in order to ensure smooth functioning of law, this cannot be oblivious to such fact. The vast, varied and scholarly jurisprudence developed by this court has been in view of these causes within Article 19. Now they say we will not allow the foreign judgment being followed. Placing reliance on vision and distinction as well as demonstrate different constitutions which involve the references answered in the above term. So the almost these cases should not be followed due to the different position of Indian Constitution and the American Constitution. Multi number of Supreme Court judgments of America was followed. You can go through all those things if you are really interested in writing article or writing thesis or writing dissertations on the subject of freedom of expression. Article 19(1). That is most important. The American decision primarily involve indictment on the basis of membership of political organization or incident free speech advocating overthrow of the government. However, under Indian law, it is not membership of political organization or free speech or criticism of government that is sought to be banned. It is only these organizations which aim to compromise the sovereignty and integrity of India have been notified to be such and unlawful whose membership is prohibited. Therefore, they say it should be membership itself is punishment. This is what the ratio of the Honorable Supreme Court of India, somewhat good judgment. But however, that is different. Once somebody is decided to resist the government, he has to face the consequences. This is the way almost all statements. Statement is different from leaders, other things. Statement is a person who stick to his principle. That's what multi number of statements were there. Initially, I was appreciating that Dr. Ramadas of Patali Makkal may be a statement, because initially he was throwing a lot of principles, but subsequently withdrew it. So he may not be a statesman. I could not find any person in India any statements. Okay, leave it that alone. The other thing was, again I am coming here about it is not demonetizations of 2000 rupees currency. This is a withdrawal of 2000 rupees currency. Since they want to stop Reserve Bank of India, stop a policy making decision to stop the circulation of 2000 rupees, which was already in current. Therefore, it is not demonetization as earlier declared, in which Supreme Court has said they would have better consulted Reserve Bank of India before announcing demonetization. And the announcement should be from the Reserve Bank of India. By following the judgment, the central government simply endorsed the Reserve Bank of India, declaring demonetization, and there need not be any rush. And sometimes there may be some part-time job for some persons who may help this 2000 rupees being converted or deposited at bank for some commission. That is also possible. Whatever it may be there, this judgment Arup Bhuyan versus State of Assam is applicable to particularly in Tamil Nadu, because in Tamil Nadu this Tiger movement is declared as unlawful organization, and some countries they are allowing, because they do not want they want always the entire globe should be unstable of principles, border disputes, water disputes, boundary disputes, annexure, seceding. All these subjects are being again and again, because they have already stored a multi number of weapons which they want to test it, as if suppose if you purchase crackers for Deepavali, and it is rest of part of the crackers are stored. The children always wanted to burst it on any other occasions. This is the way the country is also playing, and they are also playing with the life of the people. Best wishes.